Hello and welcome. Today we're going to be talking about 3 potential business lawsuits that you need to be aware of. Now, I know what you're thinking. That can't possibly be all of them. And you're right. These are the big ones. These are the ones, the most common ones. These are the ones that are more likely going to happen to you than other ones. That isn't to say this is all inclusive. So I want to be clear on that. It's very important that you recognize there are other ways to get sued. And this is just the tip of the proverbial iceberg. But the good news is because it's so big, it's a large tip. Okay. So you want to keep that in mind as we're discussing these issues, and we're going to talk about them in more depth, but you want to keep that these are just some of the potential problems that you could have in a lawsuit. You don't, or with business, you don't want to just think, oh, if I don't commit these problems or if these things don't come up, then I'm good. There are other ones, but these, I just wanted to touch on these for the thing. If you're new here, my name is Taylor Darcy from Think Legal, where I help you create the business of your dreams. So welcome. I'm excited to have you. Please feel free to leave comments and any questions you may have below. I'll do my best to answer them. If they're California specific, if they're out of California or a federal thing, I might be able to do federal depending on the question. But if it's out of California, you will need to seek local counsel in your area to make sure you're getting the right advice. So let's get started. All right. So the number one way that you can end up in a lawsuit is by breach of contract. And the real crux of this is that you may have formed a contract with someone, and you have to intend to form a contract first and foremost. And not everybody sees a contract as being written. So you can form a verbal contract, and most of the time they are binding, except for some specific instances. But the number one way that you're going to see a lawsuit is usually a breach of contract. They're easier to plead. They're easier to prosecute on because it's in black and white. And courts prefer that. You have to understand that courts prefer something that they don't have to do a lot of work on, or that it's not going to be a lot of work for the court. You also have to keep in mind courts don't want you there. So they want you to do what's best for, they want you to try to stay out of court as much as possible. Courts are supposed to be for as a last resort. They encourage you to do mediation, arbitration, other types of pre-litigation or types of settlement options that go with it. So you have to keep that in mind. Courts do not want you there. They do not make it easy on you. It is not about you. It is about the court. And it comes down to, in what we learn about in law school, one of the things is called judicial economy. The number of court cases that actually end up at trial are very, very small because the court system just does not have the resources, manpower, or otherwise to handle if every case went to trial. In fact, back many years ago, they revamped things to encourage settlement through having an expensive and drawn out discovery process. And that can be why things settle so much, is because it's so much more difficult to get to trial. And you can use the discovery process to get what's called a motion for summary judgment. And that will allow you to avoid court. And to be honest with you, court is kind of a crapshoot. Unlike TV, a jury trial is long, intensive, and may not yield the results that you're looking for because of the unpredictable nature of it. Some states, they'll allow for a 6-person jury. Other places will be for a 12-person jury. And then you can also do a bench trial. Now, these are all important because a breach of contract is simple for a jury to understand. Here's a contract. There was a breach. Here's how it was breached. And those go fairly quickly. Now, most of those settle before they even get to a trial. That's the other thing, is like 80 to 90% of all court cases settle before they even get close to a trial because of how expensive a trial is. And by the time you get to that point or close to trial, you pretty much know where you're going to end up at, and it just makes a ton of sense to settle. Now, does every case settle? No. Is each case different? Yes. And that's why you really want to make sure that you're consulting with an attorney to make sure that your case is what it is and it's what you're hoping for. The court system is meant to encourage settlement. So keep that in mind, is that the goal is to settle typically 90% of the time. Now, should you settle all the time? No, especially if the other side is being unreasonable or giving you nothing. I mean, if it truly becomes that type of dispute, then by all means, go forward, do your thing, make your case, have your attorney do what's good for you. You don't want to settle just for the sake of settling, especially if you feel like you're getting a bad deal. However, even in that context, you're still running the problem with the jury saying, we don't believe it, okay? And that means you have to convince 12 people to find in your favor, 12 or 6, or the judge. Okay, those are your options. And that can be difficult depending on the case and the evidence that you're presented with, because no case is perfect. They're not. And so even in a breach of contract that is easier, it's not always clear that the facts are not always in your favor on either side of things. So you want to be careful that you don't get too involved in the sense that it's called the sunk cost fallacy, that you've already gone this far, so you have to keep going further. I would encourage you to take that in consideration when you're doing it. You don't have to keep going. You can settle at any time because of the risks that go with going to trial, going to jury. So that's number one. Number one is breach of contract. Number two is negligence. Now, negligence is a tort as opposed to a contract action. And negligence can happen in many different ways. So negligence is you have a deep breach, or you have a duty to someone, you have a breach of that duty, and there's damages. And that's the very high level. So what happens is, for instance, as an employer, you could have negligent hiring, which means you hired somebody that you didn't do a proper background check on. You can also have negligence in your actions. If you don't behave as a reasonably prudent person, then you have a duty to someone, your potential customer or vendor or many different potentials there, you're looking at a potential negligence action. Also, you are responsible for the actions of your employees when they're under the guise of your employment. So think of a delivery person. They are delivering, I don't know, food to a restaurant. You are a restaurant wholesaler, and they get in an accident. Well, you are liable for that accident as their employer, typically. Not always. The truth is that sometimes it's not that you're liable for that, but those are all fact specific. I don't want you to get lost in the weeds. Negligence is one of the top ways that you can be sued as a business, for your individual negligence, the negligence of your employees, so on and so forth. And a liability shield does not shield you from your own negligence. It shields you from the negligence of others. Okay? So if you get an LLC or a corporation and you still act negligently, then you don't get the benefit of the liability shield. The liability shield does not protect in the case of negligence, typically, of your own negligence. So that's number two. Negligence is your big one, is your next big one. If you do something, and I just equate it to, if you do something stupid, right? The idea being that you need to behave as a reasonably prudent person, don't jaywalk, don't run red lights, then, and I mean, the oversimplification, of course, there's lots of potential ways that you cannot behave as a reasonably prudent person. And so there is negligence available on the other side. Now, this next one is California specific. Now, there might be something similar in other states, But this is absolutely California specific. So please, if you're listening and you're not from California, it's not that you have to turn your ears off, but you need to remember that because it's California, your state might have something. And so you need to make sure you're doing your research to know that this exists. But in California, it's Business and Professions Code 17200, which basically is an unfair competition or any type of act that harms the public because of your actions. So think of if, say your competitor, you see your competitor and you go and slash their tires, right? It's not fair that you slash their tires. Now, is there an intentional tort involved in that one too? Yes, but in the case of business, that's unfair to the business owner that's trying to do business. And it could be a person, it can be a corporation, it can be a limited liability company. So if someone's engaged in some type of business and you're creating havoc for them or difficulty for them, then you can be held liable under the Business and Professions Code 17200. Now, this is kind of a catch-all for a lot of different things. So I want you to keep in mind that these fit broad categories that you don't have to. There's lots of different other ones that are available, but this is a very good one that I use when I'm filing lawsuits because inevitably there's always a interference of some sort on the side of the other person. So you want to make sure that you're making that type of decision, or that your attorney is, and that you're aware of these things, right? So you can recognize that each lawsuit can contain numerous causes of action against your business. So it doesn't have to just be one. It could be, I think 12, 15, I think is my max that I've done so far. It can be lots of different ones depending on the attorney and depending on the minutia that they get involved with. So you want to make sure that I told my class, I teach business law, if we treat others with respect, we honor our agreements, we do what's right, typically nothing will happen. That isn't to say that there won't be people out there that will cause problems for you. And that's the other part of a lawsuit. You can do everything right, and if the other side does everything wrong, then you might be on the plaintiff side of a lawsuit instead of on the defendant side of a lawsuit. But that being said, you want to make sure you're doing what you're right, because then there's a defense that's called unclean hands, which simply means that the other party comes to the table with they're not innocent in this. And so you have to consider all of these things that if you bring a lawsuit, they can bring anyway. We're not going to get into the weeds on those, but these are the top 3 things that you can that are potentials for lawsuits that are going to negatively affect your business. So I highly recommend that you, if you're starting a business, if you're running a business, sit down with an attorney and talk about how you can avoid these things, right, in your business. Now, is it going to happen right away? No. But being able to talk with someone to understand how you can be negatively affected is going to go a long way towards having a successful business. The last thing you need is to screw something up, end up hurt, and having not just hurt physically, but like hurt monetarily because you made a poor choice in hiring, in so many different things. So keep these things in mind as you go. If you've gotten value out of this video, don't forget to hit subscribe and like, and hit that bell icon to get notified of when we go live. We do go live Monday through Friday, except for holidays, 11 a.m., and we'll talk to you later. Have a good one.